Hello, welcome to this presentation entitled Minority Labor Arbitrators, Issues that Arbitrators Face. I'm Howard T. Spence. I am an attorney and arbitrator in the state of Michigan. I also am a mediator and I do consulting work. In addition, I occasionally teach. I have taught business law, employment law, and discrimination law, as well as human resources management in the MBA program offered by the University of Phoenix. I have also served as an adjunct professor of law at the Thomas Cooley Law School in Lansing, Michigan. I am a former state employee and I spent the last 10 years of my career as an administrative law judge. I am now retired from that state service. I presently offer my arbitration and mediation services through Black Gold Associates LLC, which is a corporation which I own and operate. I want to dedicate this particular presentation to the Honorable Harry T. Edwards, who is the former Chief Judge of the District of Columbia Federal Circuit, and also to the Honorable A. Leon Higginbotham, who is a former judge on the United States Court of Appeals for the Third Circuit. Judge Edwards was also an instructor or professor at the University of Michigan Law School, where I was a student, and he also has the distinction of being one of the very first successful black arbitrators who provided services in arbitration through the American Arbitration Association and also through other panels. I am privileged and honored to have had the opportunity to have met Judge Higginbotham during a time when he was a visiting lecturer at the University of Michigan Law School, where I was a student. I want to extend special thanks to Professor Floyd Weatherspoon of Capital University Law School. Floyd is also an arbitrator and has a successful practice on a nationwide basis. In addition to being a professor of law at the Capital University Law School, Floyd has for several years directed and offered through the Capital University Law School an annual conference dedicated to providing continuing education and network opportunities for minorities in the alternate dispute resolution profession. I also want to extend special thanks to Mr. Jeremy Williams, who is the Director of Employee Relations at Darden Inc. Mr. Williams has been instrumental in assisting with development of diversity in the ADR profession on many occasions. He entered into a project offered through the Capital Diversity Resolution Initiative, which had as its objective providing opportunities for minority arbitrators and mediators to gain experience through live cases offered from the Darden Employment Relations area. That particular experience has been invaluable for both me and for numerous other minority arbitrators and mediators. As I indicated, I am a former administrative law judge, and it goes without saying that every judge has an opinion. I want to start this presentation by stating that the opinions which are expressed in this presentation are my opinions, and those opinions are not necessarily the opinions of any arbitration panel or association on which I serve, nor are they necessarily the opinion of any other arbitrator. I recognize that some of the opinions which I express in this particular video presentation may be controversial. Indeed, some other arbitrators may dispute the validity of the opinions which I offer here for your consideration. Hopefully the information and the opinions expressed in this presentation will engender some thought and discussion of the topics which are considered. Again, I acknowledge that some of my opinions may not be absolutely correct, and I am open to discussion and reconsideration of my opinions. My objective in this project is to encourage thought and learning among those who view this presentation, and ultimately, perhaps, to enhance diversity within the ADR and arbitration professions. The video presentation which you see today is actually the third part of an extended presentation dealing with the topic of issues which are faced by arbitrators. The focus of that presentation has been on problems and issues faced by minority and female arbitrators, but many of the issues which are raised and the discussion which is offered in this series is actually relevant and pertinent to arbitrators of all races and ethnic backgrounds. The first segment of this particular video presentation has also been posted on the internet for your consideration. If you have not already viewed it, then I certainly would want to encourage you to do so. That first segment dealt with the issues relating to control of the hearing process itself. That segment also dealt with the role of the arbitrator in that process, and a third part of that first segment dealt with how to deal with bias and conflicts of interest in the arbitration profession. The second part of this series, dealing with issues faced by arbitrators, raised two general areas of issue analysis and consideration. The fourth area of issue analysis in this series dealt with the topic of when the arbitrator gets sued or dragged into court. The fifth segment of this particular presentation series, which was recorded and discussed in part 2 of this video presentation, dealt with some of the issues which arise in the business and operations of the arbitration practice. The part of the presentation which we are considering today, which is the third part, deals with two especially interesting and I believe important topics or issue areas. Those are disclosure issues and also issues which relate to race and ethnicity considerations which enter into the arbitration process itself. I want to start out looking first at the topic or series of issues which deal with disclosure. Disclosure is very important, and in fact it is one of the areas that is reinforced among new arbitrators and also arbitrators who have been around for a while. Disclosure basically means telling the parties enough about you so that they can understand a bit about you and make a decision for themselves as to whether or not they can trust you to handle cases that they present. Sometimes those cases have very significant impact for the parties, and it is important and crucial to them that the parties know that they can trust the arbitrator to be both unbiased and fair. I want to take a moment to look at the topic of shopping for an arbitrator. As I indicated, because of the significant stakes or potential consequences of litigation, parties to arbitrations, they strive to make litigation choices that favor the outcomes that those parties desire. One of the most significant variable determinatives of outcomes in any type of litigation is who will be the trier of fact or decision maker. No matter how good a case you have, there is somebody who will be deciding that case, and you need to understand and believe that they can make a fair decision and that they can understand the presentation which is being made. Although parties normally cannot get away with judge shopping in normal court litigation or civil litigation, Parties routinely select or reject arbitrators based upon fears, expectations, hunches, or the records or reputations of the arbitrator. Since an arbitrator is essentially a judge for hire, all bets are off in terms of the parties being precluded from knowing as much as they can about the arbitrator who will be judging their case and making judgments as to whether or not they want that particular person to be the one who adjudicates their case. Parties routinely scrutinize arbitrator disclosures in an attempt to determine which arbitrators are best from their perspective to hear their cases. A general topic that needs to be considered whenever we look at disclosure is what to disclose and how much to disclose. And this is one of the first decisions that an arbitrator has to make when he or she is offered an arbitration assignment. Disclosure is, again, regarded as a very important part of the arbitration process. When an arbitrator is approached to be offered an opportunity to adjudicate or arbitrate a case, the associations or the parties who approach the arbitrator require that arbitrator to answer a number of questions that would allow the parties to understand the arbitrator and to be confident that there are no conflicts of interest or other considerations which would cause that arbitrator to be less than fair in the adjudication of their arbitration claim and dispute. The rules of the American Arbitration Association and also the rules of FINRA indicate that arbitrators can be kicked off their panels for less than full disclosure. This particular aggressive posture by the associations is certainly understood, given the fact that inadequate disclosure by an arbitrator can jeopardize the finality of the arbitration award itself. There are actually very few ways that the parties can challenge or appeal the decision of an arbitrator once the record is closed and the decision is issued. One way that a party might be successful in challenging an award and appealing an arbitrator's decision is to be able to show an abuse of discretion. Another way that can also be the basis for challenging or reversing an arbitration award or decision is to show bias by the arbitrator, and sometimes that goes along with being able to show that the arbitrator had some characteristic or some event in the arbitrator's past that, if the party had known about it, would have led that party to have rejected the arbitrator in the very first instance. In other words, if I knew now what I knew then, I would not have taken this particular arbitrator. And depending on what that particular aspect of the arbitrator's history is, that might be sufficient for a court reviewing an arbitrator award to conclude that a less than fair hearing was held, and that would be the basis for reversing the arbitration decision. The bottom line, therefore, becomes that good arbitrators disclose, and they disclose fully. However, even arbitrators who disclose and disclose fully have to make some sort of choices and some sort of decisions in their own mind as to what is really important and what should be disclosed. There are many things that occur in a person's history or past, many associations, many types of relationships which could be reported, but the arbitrator initially needs to take that first step back and do a self-assessment to determine what is there in my past, what is there in my mind that I believe that a party would want to know about me, and what is there that I think is important myself that would have the party want to have an opportunity to consider that information before assigning me or offering me an assignment to an arbitration case. One thing that I tell arbitrators and prospective arbitrators when I approach them and discuss the issue of disclosure is that they might as well disclose as fully as they can, because whatever the arbitrator does not disclose about the arbitrator, they, the parties, or anyone else, can probably know anyway, especially if it is something that is interesting and something that might be pertinent to the arbitrator's ability to do a fair hearing and to arrive at an unbiased and objective decision. The world has changed. I like to say that in today's internet world, your deepest, darkest secrets are actually perhaps only a Google away. Internet search engines now have developed the sophistication and the breadth that they're able to find out a minutia of details about almost anyone who is actually out on the internet or engaged in professional activity. The parties, if they want to know, they can know your politics. I was surprised at one point to see that when I Googled myself, which I recommend people do, I had made political contributions in 2008 to one candidate for president, which amounted to a sum which I thought was very high for me. And I guess that had occurred as a result of my making $10, $20, $30 contributions at a time, but it aggregated to an amount which I thought was impressive for me. And the reason I was able to find out how much I had donated, I certainly wasn't keeping track, but somebody on the internet was, and one day when I Googled myself, I found out not only where I lived, but how much I had actually donated to that candidate as of that point in time. And the information didn't come directly from the candidate's campaign itself, but it was out there on the internet. So if somebody wanted to know what are the politics that Howard has been involved in the past decade, they can find that out simply by Googling me, and they could probably also find out that at one point in time I had run for a political office as a county commissioner. If you write a comment on any social media on the internet, whether it's Facebook, professional locations like LinkedIn, if you use Twitter, anytime you're out there, whatever you put out there is open to view and consideration. These search engines just go around, they gobble it up, and the power of the computer and the internet is so great that they can associate this information so that in a matter of less than a second, people can know more about you than you perhaps have ever considered telling them. And sometimes you can find out things about yourself by Googling yourself that would even amaze you. Again, I often encourage people to Google themselves. I have Googled other people. I guess it's going to be a part of the environment from this point forward. I think that not only arbitrators, but people in general who get involved in professional activity and who venture out onto the internet have to realize that privacy as we have traditionally known it is pretty much a thing of the past. And you see on this slide what I was able to find out about myself in apparently less than a fifth of a second or less than a fourth of a second, and there were literally hundreds of entries that I was able to find out about myself just by Googling my name. By going out into the internet and Googling yourself or doing internet searches, you can find writings or opinions that have been published by the arbitrators. Some of these writings and opinions are not actually generally available. When I went out, I was somewhat surprised to find some of the decisions in wage and hour that I had written as an administrative law judge 15 years ago. I don't know how in the world those particular decisions got onto the internet, but they popped up when I Googled myself, and I read a couple of those wage and hour decisions from 15 years ago, and I kind of remembered them. And again, I was just amazed that this type of information and this detail of information is available on even a casual search basis. by going out into the internet, prospective clients, prospective parties, they can find evaluations of you, comments of and about you, and they can share that information widely with other professional groups and colleagues on a nationwide basis in just a matter of a very short period of time. One thing that I would advise you, and one thing that I learned, perhaps a little bit painfully, was that the internet and these search engines can have a deeper memory than you or I would likely have as human beings. Information which is captured on the internet never really actually goes away. Sometimes it becomes dated and you may not see it when you go and look for it 6 months, a year, whatever period of time in the future. But the reality is that these search engines, even if they don't report data on any one particular instance for any number of reasons, that information has not really been deleted permanently. And if someone wants to find out something about you and is willing to go back and look at some of the internet archive sites, they may find things that you put on the internet or someone put on the internet about you from a decade or more ago, which has not actually been visible. And this also shows up when you are making comments on social media websites like Facebook or whatever. Sometimes information that is there and it's offensive and you want it removed, or it could be inaccurate. It could be removed from your page, but it's not removed from the internet. And it's merely tucked away somewhere in some archive and can be retrieved, much to your chagrin, I suspect. 3 years ago, the internet reminded me that it had a deeper memory than I have when it brought to my attention some information which I had really forgotten about myself. Now, when I was Googling myself 3 years ago, the internet told me that in 1986 I had stipulated to a 60-day voluntary suspension of my law license without automatic reinstatement. And at the time that that was going on, it was a hectic part of my life. I was going through a personal divorce, trying to manage 3 young children on my own, and also working full-time as Deputy Insurance Commissioner for the state of Michigan. So it certainly was not a time that was very clear in my mind 15 years later. But what the internet told me, and what I recalled right away when it was brought to my attention, was that in 1985 or 1986, I had failed to visit an inmate in an Upper Peninsula prison within 30 days of my appointment as counsel for that particular inmate on appeal. And at that time, there was a requirement that court-appointed appellate counsel actually visit and discuss with their client the details of the case and the basis for the appeal. This occurred with this particular client during the time when I was going through this divorce and had all these other issues which were taking priority in my life. And I didn't get up to the Upper Peninsula prison where this inmate was housed within the 90 days. In fact, the inmate was approximately 500 miles removed from where I was physically residing at that time. And since I didn't get up there within 90 days, as is typical of clients who are focused on themselves and their immediate needs, he filed a grievance against me with the State Bar Grievance Commission. And when the State Bar Commission approached me about the failure to actually communicate with or visit that inmate within 90 days, mea culpa. I was guilty, and I resolved that through settlement. But in any case, when I did this Google, and it still shows up today, I found the following information, and that at least information had been corrected to indicate that in 1986 I had been voluntarily suspended for a period of 60 days with automatic reinstatement. And if you click the links, you could probably find out some of the information that the State Bar brought to my attention and provides to the public. I think that this type of information is certainly less onerous than some of the information that can be put out on the internet about you by people who either don't know you or have different agendas which may not be in your best interest. At one point, I did come across a website, again by Googling, which had my name on it, and I looked at the website in particular because the website represented itself to be a website which listed the worst lawyers in the United States. And obviously it was put together for sensational purposes. I didn't think then I was one of the worst lawyers in the United States, and I certainly don't think it now. Since that time, I have, in fact, become an administrative law judge, served successfully, and I think I give good service to my clients at all times, except perhaps for this one inmate that was in the UP. So I'm sorry about that, but I underscore the point that what I had not disclosed, the internet did. And as of that point in time, I had not thought that this was something that I would have disclosed even if I had remembered it. But I do disclose certain types of things now that are on the margin, and perhaps I would not have thought in the past I would or should even disclose. At the time that I had that particular 60-day voluntary suspension of my law license back in 1986, and since that time, up until very recently, none of the ADR panels on which I was a member specifically asked if any applicant for the panel or if any arbitrator on the panel who was being considered for referral out for a case had ever had their law license suspended. And I've noticed that within the past year or two, some of the panels have added that particular question on the pro forma disclosure form that they do send out on behalf of potential parties to adjudication. And I have routinely disclosed this 60-day, and then you have to give your explanation. After I was reminded of the suspension history, and even before the panel started asking, I began to disclose it because, again, a part of the concern or issue that an arbitrator has to face is what is important. What is it that if I don't disclose it, someone might, after the fact, use as a hook to attack or challenge a decision I made which did not please them and which they thought should be reviewed in the courts. I should add that disclosing the information about that one particular 60-day suspension has never, to my knowledge, resulted in my being denied an arbitration appointment. And as I indicated, even in retrospect, looking back, if I had recalled the 1986 information about the voluntary suspension, I'm not sure that I would have concluded that that particular information would have been helpful to a prospective party trying to evaluate my ability to provide a fair, neutral, and competent arbitration hearing and decision at some point after 2000 or 2005, whenever I first began doing independent arbitrations through some of the referring associations. Along the same line of disclosure, again, so many judgment calls. I guess arbitrators are paid to make judgment calls, but the judgment calls go to the issue of what should be disclosed. And one of the issues that sometimes comes up and is discussed is, should the arbitrator disclose either directly or indirectly personal information such as race or ethnicity? And again, potential parties want to know everything about an arbitrator which is relevant to his or her ability to successfully and fairly conduct an arbitration hearing process. Another aspect of this particular issue or topic or the consideration about what to disclose is that although the parties may not admit it or state it directly, sometimes demographic data such as race, ethnicity, or political activity is of interest to those potential parties. And I say that because, as I indicated in another segment of either this presentation or a presentation dealing with why parties go to arbitration rather than to the courts, the consideration about demographic characteristics such as race and ethnicity and political activity is certainly of interest to these same parties when they litigate in courts. Another side of that same issue about should the arbitrator disclose personal information such as race or ethnicity comes from realizing that some potential parties may actually affirmatively be seeking minorities or females to hear some of their cases. Sometimes, as a marketing tool, minority arbitrators may want to let potential parties know about their ethnic or racial backgrounds. Again, if the parties are really interested in knowing, they could probably find out either through the grapevine or talking with colleagues or going out on the internet and seeing what they could dig up about you at that point in time. But again, sometimes in some settings, the parties may think that it would be in their best advantage to go out and find an arbitrator who has some demographic that might be pleasing or helpful to the party or to the party's constituency. And again, if they want to know, won't they just investigate on the internet? Should the arbitrator disclose race or ethnicity? Another aspect of disclosure of race and ethnicity or any other demographic factor is what I call subtle disclosure. Sometimes it may not be politic to go out and say, hey, I am a minority arbitrator, consider me. But you will find that there are all sorts of cues or clues which an arbitrator can give to prospective parties in items such as resumes and profiles. Those resumes, profiles, and informal disclosure forms sometimes disclose demographic data such as race and ethnicity. If you take the opportunity to look at the resumes of some of the potential arbitrators who are referred out to be considered for appointment in your particular case, the cues and the clues which you find on there are pretty obvious if you are thinking about it and looking for it. As a minority arbitrator, on my resume, when we start talking about memberships or associations that I have had in the past, which may be relevant to my ability to adjudicate a case, I might have on my resume the fact that not only am I a member of the American Judges Association, but I have also historically been a member of the association named Black Judges of the State of Michigan. Now that is a clue. Information such as fraternity information, I'm a member of Alpha Phi Alpha fraternity, that is a pretty good indicator or clue to somebody who is focusing on that issue that I may in fact be black or at least a minority. So the group memberships that are reported also provide clues about the race or ethnicity of a person being considered for appointment as an arbitrator. And should that occur? Well, without putting a value on it, I think I would simply say that it does occur, and that I think it's a part of life. If I wanted to ignore the fact that it occurred and appear to be blind to the reality of these messages and the inquiries made about my race, ethnicity, political background, whatever, I could in fact pretend to be blind, but the reality is that if somebody thought that was important, they would still be able to find that information out pretty easily. Again, the dangers of social media like Facebook, being involved in a community. Arbitrators are people just like everybody else. They have lives. They get involved in civic activities. They raise children. All this type of information is out there. And the same thing is true of judges. Now, again, as I have sort of indicated earlier, when you're out there on the internet, you're not completely anonymous. Just because you have taken a name on a profile of the Masked Avenger doesn't mean that your identity is safe and that people will not know that you are in fact Howard Spence, the Arbitrator. Not that I am the Masked Avenger. I wouldn't recommend that you go out and Google that, because hopefully you will not find that I'm associated with anybody called the Masked Avenger. But the point I'm trying to make is that when you're out there, you may think that you are being anonymous to a certain degree, but you are not. And those of you who have done arbitrations in the labor setting or the employment setting recognize that many individuals are actually fired or disciplined and lose their jobs as a result of activity which they engage in while at work on the internet. And so just a word to the wise, and also I would suggest that internet behavior has the potential for straying to the dark side. When someone gets bored or lonely, certainly they may be running to dating sites or worse. Again, I have found that just like with email, it's very easy to quickly respond, type out a few words and letters and shoot it off and it's gone. And the only problem with that type of lifestyle which now exists of immediate response is that it's gone possibly even before you think about it, and then you forget about it because it's so easily forgotten, but it's out there and it's very difficult to take back or to not acknowledge in terms of its existence when it's there in pretty much hard copy, physical, electronic versions. The same thing with postings and tweets. When we get into the political season and sometimes we argue with our friends online, we try to persuade people, and those postings and tweets can tell things about you, and people can find out what you tweet and what you think. Something as innocent as going to a site and clicking on the thumbs up or thumbs down, something I like, something I dislike, that type of information on the internet, again, telling people something about either your mindset or perhaps your character or the social activity in which you get involved. Another aspect of change which has occurred as a result of us evolving into this internet society is that we have many more contacts as a result of being out on the internet. It's very easy to actually interact with a large number of people on the internet compared to what historically we might have interacted with in our churches, in our offices, whatever. And in fact, many times we're interacting with people who are just a figment of our imagination. We've never met them, we may not have seen them, but they become very real to us. We conduct business with them, we interact with them because through the keyboard, through the monitor, they're right there and they're very real for us. Moving away from the general topic of disclosure, I want to now take some time to talk about race and ethnicity as decision-making factors in arbitration. This particular series is a part of an overall or larger presentation series which deals with diversity in alternate dispute resolution and in particular diversity in the arbitration area. And I want to start out this discussion by stating that in some ways we are all similar as adjudicators, but in some ways we are all quite different. And I think it kind of goes to our humanity. On an individual basis, we think differently based on our experiences, and sometimes those different thought practices or procedures or patterns will impact on our judgment and on some of the conclusions which we make in life. In this general area, first of dealing with race and how that impacts on decision making, I think I need to remind the audience of the concepts of stereotypes. And stereotypes are actually mindsets that we develop based again on our experience that allow us to make quick judgments. And in fact, stereotypes generally go with prejudgments. And to a certain extent, stereotypes and prejudgments are helpful and necessary to us as individuals because it allows us to make quick judgments from which we can deviate as we gain more information about a particular person or incident or situation. So we all do it, and again, it's I think very human, and sometimes it's not pernicious. It's not something that causes difficulty. It's not something that causes a lack of fairness. It is the reality of being human. And in the same vein, there are stereotypes generally of black people, racist stereotypes, some positive, some negative, and the stereotypes for black arbitrators or minority arbitrators, those stereotypes often are derived from stereotypes generally which someone has placed on a racial group or an ethnic group. And so just looking briefly at some of the stereotypes which I've encountered or suspected dealing with the area of race and characteristics of people in racial groups, one of the stereotypes is that blacks, for example, are likely to be more sympathetic or empathetic to the underdog, to other people of color. They tend to favor employees as compared to employers, and it goes on and on and on. And that particular attitude toward blacks would certainly be in the mindset of a large number of parties who would be attempting to determine which of several offered candidates to be an arbitrator they should consider. And sometimes those stereotypes, I should say probably often those stereotypes would cause parties who were not blacks or minorities to stop and wonder if they should take a chance on selecting an arbitrator who might have these stereotype characteristics. Another set of stereotypes dealing with characteristics, for example, of black people, which could impact upon the selection of black arbitrators, is the stereotype or the thought within certain individuals in our communities that blacks are not really well prepared. They are not usually focused. Certainly they're not interested in their cases. They're not professional, and they're not able to understand well. And these stereotypes were emphasized historically in some of the movies that you may have seen. It became pretty clear, people would laugh about the obvious, that generally the stereotype was that black people are lazy, shiftless, and stupid. And those stereotypes are certainly unfair. They're very likely inaccurate for most people who are people of color, but at the same time, it is a part of the racial environment and how people interacting in a racial environment see each other. There is, in my opinion, resistance of some people to using minorities and females as arbitrators. Some parties deliberately go out of their way to avoid using minorities or females in the arbitration process, in part because of stereotypes and also in part because of some information that they have dealing with their fears of how people of color and female think about determining innocence, guilt, making judgments generally in decision-making roles. The people who are resistant to using minorities and females as arbitrators also seem to fear that there would be a lack of partiality, or rather there would be impartiality by minorities in the decision-making process, especially when one party, and likely the other party, is a member of the same minority group as the arbitrator. In other words, there is a suspicion, which is prevalent and perhaps not spoken, that minorities, black people, would tend to favor other minorities and black people. And it's out there, and the accuracy of that suspicion is certainly in and of itself very suspect. That's not to say that sometimes people of color may not favor other people of color when they're flipping a coin trying to decide X versus Y. But the same thing is true when you see a white arbitrator or a white male arbitrator attempting to determine an issue or a fact in which one of the parties is of the same majority group as the white male. And it's a part of the nature of human social psychology, and it goes both ways, us versus them. And the arbitrator, the professional, the person who is trained to be fair in adjudication, has to step back again, be aware of what could be the personal biases of the arbitrator, and then make a determination and a commitment in his own mind, even if he doesn't speak it to the parties, that he or she would be fair and that they would not allow any sort of biases or stereotypes or experience to unfairly influence their decision making or the way that they might want to receive evidence and conclude cases. After that introduction, I'm going to suggest to you, and again, not everybody would agree, certainly not every minority or female would agree with me, but I do truly believe that many minority and female adjudicators may actually approach problem solving and fact finding differently than white male adjudicators. And again, being open and honest about it, I think it's a part of the reality of being human and a part of the social psychology that deals with how humans interact with people who are different from us. How is it, perhaps, that race could affect a minority arbitrator's decision-making process? I believe that some minority adjudicators are more likely to make credibility and fact determinations a little bit differently because of their own cultural background and history and experiences. We all are slaves to our memories and to the experiences that we have when it comes to being able to make stereotypes and move forward and to make decisions in the future that impact our own lives and or the lives of others. And I think that one example of what some parties believe that would cause them to avoid utilizing minority arbitrators is perhaps true, that I would suggest that because of widely known historical facts and experiences within the black community, for example, black arbitrators may be less predisposed or prejudiced, less rejecting, immediately skeptical of arguments raised by minority parties or others that they were illegally discriminated against or treated unfairly. Now, what am I saying? What I'm saying is that because I may have been involved in a situation where I was discriminated against once, twice, whatever number of times in my own life and history, when someone comes to me with a case, perhaps, and they're alleging that they have been discriminated against based on their race, I don't go into that case predisposed to think that they are certainly way off base, that such a thing could not occur. I am not skeptical immediately of the fact that there is unfairness in the world or discrimination in the world. So I go in there with a mindset that yes, discrimination may occur, does occur, and it could have occurred in this particular situation. Let's take a look at the record and see what you have to support your allegations that you were illegally discriminated against based on your race or some other protected category or characteristic. So, having said that, there are, on the other side of the coin, some people, and I suspect that they would primarily be white males, who would not be so willing to believe that there is unfairness in the world or discrimination in the world based on race or gender or whatever. And so they might go in skeptical of arguments which are raised by minorities that they were discriminated against, that they were discharged for illegal or wrong reasons. And so as we look at it, that same white adjudicator or arbitrator has the same duty as the black adjudicator or arbitrator to step back again, do a self-assessment of bias, and then to make a commitment both to himself and also perhaps to the parties that that adjudicator, that arbitrator, would be fair and open-minded and willing to make a decision based upon the record evidence rather than upon some stereotype or predisposition or suspicion that the arbitrator might have when the case first presents itself as a piece of paper with a claim. Sometimes minorities expect that they will get more justice and fairer decisions from minority adjudicators. I think I've had experience where I've walked into the room and somebody saw that I was a black arbitrator, and that somebody may have been black, and there may have been subconsciously a smile on their face. And the same thing is true generally in courtrooms. When you sometimes go into court and you're a minority and you see that there is a minority judge, or if you're female and you see there is a female judge, right away there is a different degree of ease and confidence in the system, because you think you may get a fairer shake from somebody who can understand where you're coming from and may not actually have stereotypes which are adverse to your interests. So that, I think, is something that you will see. And I think that's the other side of the coin, where you have a party, perhaps a white party, who is skeptical or resistant to using a minority arbitrator because they think that they may get a fairer shake, a more informed and better decision from someone who is like them. Because there is this widely felt predisposition that perhaps being a minority you may be sympathetic to other minorities, there is sort of a perverse reverse discrimination which occurs. There is a danger that some minority arbitrators will overcompensate for being a minority decision maker by giving minority parties or witnesses closer scrutiny, tougher credibility checks, and by setting burdens of proof higher for minority parties. In other words, if I'm black, I don't want to be perceived as favoring blacks, so therefore I'm going to be tougher on blacks. And you see that also. And I don't really know what to say about that. It's an observation, and I think I am not the only one who has made that type of observation and come to that type of conclusion. When all is said and done, the process that an arbitrator needs to go through when we're dealing with either race-charged or race-implied cases is that the arbitrator needs to separate what is suspected in a case from what is proved on the record. And to buttress this particular discussion, I would give you an experience I had as an arbitrator on a FINRA case. And even though it was a FINRA case, it was an employment case, and the claimant had signed an arbitration agreement, which is very common in the securities industry, stating that any and all employment-related disputes would be arbitrated rather than taken directly to the courts where they could be enforced or prosecuted as civil litigation. An example would be for Title VII, and there are a number of other employment laws that many people take directly to court, but more and more those cases are not getting to court because the employers or one of the parties negotiates that those cases will be resolved as disputes in arbitration. And this particular FINRA case was one of those cases. The claimant or plaintiff was a black female, and she had alleged that she was discriminated against and forced to leave her job in the securities industry because she was a black female in an industry which was predominantly white. And she had attempted to take her case directly to the federal courts as a Title VII discrimination case, but because of the arbitration clause in her employment contract, that case got bounced back from the federal court to this FINRA arbitration proceeding. Now, I've indicated that the profession, the arbitration profession, is not really a diverse profession, and by and large, the great majority of arbitrators that you will see are actually white males. And FINRA typically will use panels of arbitrators to decide this type of case, a tripartite panel, 3 arbitrators. And in this particular case, where I got selected and handled the case, out of the 3 arbitrators, I was a black male. One of the other arbitrators on the case was a black female, and the judge on the case, who was the chair of the panel, the arbitration panel, was a white male, an older white male. And we went through the hearing. It ended up being, I think, a 4 or 5 day hearing. Tons of information was put on the record, and throughout that particular proceeding, I had undoubtedly begun with my experience believing that it was possible that this woman was discriminated against, but in my role as an arbitrator, and given my commitment to try to do the fair thing, the right thing, the lawful thing, I listened carefully for those several days, waiting for this particular claimant or her attorney to put some evidence on the record which would show that the discharge was in some way related to the race or the gender of the claimant. And that evidence never got into the case. And in fact, during the course of the development of the case record, I'm sure that the arbitrators may have raised their eyebrows and wondered, well, when will we get the evidence that there was discrimination which would justify us giving some sort of award, in this case for damages? And the claimant was asking for very significant damages in that case. That particular claimant never developed on the record evidence that any of the 3 arbitrators on that panel thought would even give them a basis for believing that the discharge in question had some relationship to the woman's gender or race. And so in that particular case, based on what was put on the record, I came to the conclusion, and the other 2 arbitrators or judges came to the conclusion, that this particular situation was not a discrimination case, and certainly there were no damages in that case which could be attributed to prejudice or discrimination. The company was able to show that there was a rational basis for discharging this particular employee, and so we dismissed what the employee characterized as a very large reward type case. We dismissed it, and the claimant got nothing because we concluded that there had not been discrimination. The point of that particular discussion was to highlight some of the points that I'd earlier made. The black female claimant undoubtedly was happy to see that 2 out of the 3 judges on her panel were black, and the black judges on that panel may have come in with experience that caused them to believe that sometimes black people get discriminated against, so they weren't skeptical of her claim before they had an opportunity to look at the evidence developed. But again, those 2 black arbitrators or judges, along with the white judge, you shake your head, and a unanimous decision, and not really any discussion of significance about, well, couldn't there have been, shouldn't there have been, none of that came up. We looked at the record, and the case presented was woefully short of anything that would be persuasive of the claim of the black female that she had been discharged for illegal racial reasons. Another aspect of how race and ethnicity can impact the determination of an arbitrator deals with the fact that one of the major tasks of the professional arbitrator is to make determinations of credibility of the witnesses. Although there is often substantial documentary evidence, the arbitrators always like to look at the witnesses, especially if there is a dispute or contradiction about factual matters, and the arbitrator must decide basically what are the facts of the case, and that basically evolves down to a determination of credibility. And we all know that witnesses sometimes stretch or distort the truth, and I suspect we all believe that witnesses sometimes fail to recall correctly or fully. And among arbitrators, I think that we probably all know that sometimes witnesses lie. And so with that particular mindset, the job, the duty of the arbitrator to make credibility determinations certainly is preeminent. Now, as I have suggested, arbitrators and judges make their credibility determinations by weighing the statements and testimony of witnesses in light of the actual life experience that the arbitrator or judge may have had himself or herself. In other words, I am going to believe you or not believe you based upon something that may have occurred in my life, something I believe, something I've learned or know, based upon my assessment of how you present yourself, body language, whatever. There's something about you that helps me decide whether or not you're telling the truth and allows me to make a credibility judgment. An example of this is, and would show up if one of the parties in a litigation came and was testifying under oath about the fact that he had seen or she had seen an elephant fly. Well, you try to keep an open mind, you take this testimony, and you're thinking in the back of your mind while the testimony is coming in, well, you know, I've never seen an elephant fly, but if you say so, and then you go one step further and you say, well, Walt Disney told me that he saw Dumbo fly. Maybe I should see that movie again. Is it really possible that an elephant flies, and should I believe your testimony? Arbitrators with different life experiences and different cultural backgrounds may evaluate the testimony of witnesses very differently. I'm going to take a moment to recount an experience I had, a war story, which I hope will provide an example of how differences in race and culture and exposure to history can impact upon a credibility evaluation. And so I'm going to give you a real-life example of what I call divergent race-based credibility evaluation. And the example that I'm going to share with you comes from a litigation I had, and it was in an administrative forum rather than in an arbitration setting. But the situation, the issues are basically the same and can be carried over to determination of credibility in an arbitration setting. But in any case, I had been an administrative law judge for 10 or more years before I retired from the state of Michigan. And following my retirement from the state of Michigan, I was involved in some litigation. And a part of the litigation or caseload that I had dealt with or focused on defending individuals who had been alleged to have violated some requirement of their license. And The situation which I was involved in was with a black social worker who had been charged by the state with having had a consensual sexual relationship with a client, which had occurred only within the confines of the therapy room for a period of approximately a year. And I was a black attorney, I still am, and my client was a black social worker. And we have the situation where the black male social worker was alleged to have been involved in this consensual sexual relationship, and the client, the black male social worker, denied any inappropriate or sexual contact with the woman whatsoever. And this was the classic he said, she said type of situation, because no one else knew. I had not been in that hearing room, I had not been in that therapy room when this alleged misbehavior supposedly occurred. Neither had the Assistant Attorney General, who prosecuted the case on behalf of the state licensing agency, and neither had the white male administrative law judge who had been appointed to hear the case and was presiding over the case. In this type of licensing proceeding, especially where there is the potential for a license discipline like revocation or suspension or reprimand, whatever, the state, the Assistant Attorney General, had the burden to prove that the alleged sexual relationship had existed. So that was the state's burden. At the end of that particular proceeding, I had made judgments on the credibility of the testimony of my own client, of course, and I'd also made some judgments on the credibility of the state's complaining witness, who alleged that she had been involved in this particular situation with my client, which was sexual but consensual. And my reasoning thought to get to that conclusion was based upon my assessment of credibility of my client and assessment of credibility of the white female who was a complaining witness for the state. And a part of my reasoning process undoubtedly was the following. As a black male, as a black educated male, I am very aware of the fact that there is a very long history in the United States of literally thousands of black men getting lynched because a mob, a riot had occurred, and the mob had been incited against these black men by a white female who claimed that they had been either raped, seduced, jilted, or otherwise offended by a black man with some sexual innuendo. And this is history that is ingrained in the memory of black people in the United States. I think that anyone that is educated and knows about black history would be aware of these thousands of lynchings, and in fact some of these lynchings may have occurred in situations where the person making this judgment, whether it's an arbitrator or another black person, they may have even known of some people who were impacted by these lynchings. So that's a part of the background, history, or environment that would impact on the thinking of a black male, whether that black male was an arbitrator, a defense attorney, whatever, or a juror. You know, they certainly have to be aware of the fact that it ain't necessarily so. So there's this degree of skepticism. Just as I indicated earlier, black arbitrators may not be skeptical of the allegation that racism exists, that illegal discrimination exists. They may be more receptive to that type of argument. Apparently, white people, especially white men, may be less aware of that history, and they may be more skeptical of claims raised by black men that they didn't do a certain type of thing. And that is in fact what occurred in this case. But I think a part of the history in the United States where this type of problem is emblazoned on the memory of black people and so many white people may not today be even aware of this history. An example would be, if you look and perhaps Google Rosewood, Florida, where in 1923 a whole city or village of black people in Florida was decimated, wiped out during a race riot, and the white population had come in. There had been multiple lynchings of black men in that particular community, and it all had occurred because some white female had gone back to the white community and said that she had been either raped or solicited sexually by a black man. And in anger and horror that such a sexual assault could have occurred, the mob entered into a race riot, and many black people, many black men were killed, lynched. So that is a part of, again, the environment or history that a black arbitrator would be aware of, and that might impact on how a black arbitrator looked at, or a black advocate looked at the denial by a black man that he had been involved sexually with a white female. Sort of race and sex intensified, and that is the example that I'm using to highlight the psychological differences in how this type of controverted fact would be approached. But again, there was no evidence or corroboration whatsoever to the woman's claim of consensual sexual activity with the social worker, and the state has the burden. So right away, I think that there are concerns raised which an arbitrator has to be aware of, or in that case, the administrative law judge. But the situation gets enhanced. And if we continue to think about how my own thought processes went in evaluating the credibility of the black male social worker vis-a-vis the white female who alleged the consensual sexual relationship, other facts came out. And one of the things I undoubtedly thought about was the woman had given an incredible explanation about the sexual activity itself. It was not one or two things. There were many things that she stated about their sexual relationship which I thought were incredible in and of themselves. But one of the things that I still to this day cannot understand or fathom was the fact that this white female had, for whatever reason, determined that she was going to destroy this black male social worker, and so she had sued him civilly for malpractice, and that lawsuit had been stipulated dismissed with almost no financial recovery at all from the insurance company who defended that malpractice case. The woman got less than she probably had to pay her attorney. It was basically a settlement agreement that reflected the fact that after depositions they weren't going to be able to prove this case. The woman had gone to the local county sheriff department and filed a complaint, and the prosecutor, based on what the woman had related that the acts occurred were consensual, refused to prosecute it. So then she went to the state licensing board and was able to persuade a white female assistant attorney general that these things had occurred, and so the state was attempting to get this license. But during the course of my cross-examination of this woman, and the administrative law judge was very reluctant to allow me to attack her credibility. He was very protective of her on the record, but I was able to ask some questions, even though the adjudicator said those questions were not really relevant to the issue of whether or not he had had the sexual relationship, which he denied. But I started out by asking her about a tattoo that my client had on his groin, right above his penis. And in a deposition, my client had been defended by the insurance company. I was not involved in the civil case. And in a deposition, the black male social worker had said, I didn't do it. I can prove I didn't do it. If I did it, she should be able to describe this tattoo I have on my groin. And of course, that was in the deposition, and that had occurred a considerable amount of time before this licensing case finally came to light and got prosecuted. And the woman anticipated that question, and she said, I know you're going to ask me about the tattoo on his groin, but I can't describe it. I never saw it. And I asked her, well, why didn't you see it if you were having all of the sex that you have alleged and which shows up in the state's complaint? You know, there was vaginal intercourse, anal intercourse, oral sexual activity. If you're doing all those things, how did it happen in more than 30 different situations or separate therapy sessions where you claim the sex occurred? How was it that you had never seen this tattoo? And the woman said, well, the reason I didn't see it was that he was afraid somebody would come to the door during the therapy sessions, and he never took off his pants because he didn't want to have to explain why he didn't have his pants on if somebody came to the door. You know, I was kind of shocked at that testimony. I think it goes beyond racial experience. I hate to indicate that I have my own ideas about how sex occurs, but that didn't seem to me to be a very persuasive explanation as to why she didn't know about the tattoo on my client's groin. But, of course, the administrative law judge didn't want to let me pursue that. I did ask her during this time that he refused to take off his pants because he was afraid someone would come to the door. What were you wearing? She said, oh, I was completely naked. So apparently the black social worker wasn't intelligent enough to anticipate that someone coming to the door and finding him without his pants on might be curious as to why she was naked, but that's a different aspect of the factual situation. What I found to be completely, in my mind, an indication that there was a problem with the credibility of this white female was I asked a question which had not previously been asked, and I didn't know the answer, but I asked it anyway just because I was beginning to have doubts about the testimony she was giving. I asked her, well, you know, you claim that you have performed numerous acts of fellatio on this black male social worker. Yes, I did. It was one of the favorite sexual activities that he enjoyed. And you did this on 30 different sessions, 30 different separate distinct sessions. Yes, I did. So I asked a question. Well, was he circumcised or uncircumcised? And apparently in the preparation of this witness, neither the state attorney general nor this woman had anticipated that question. And you could just see when I asked the question, she was pretty much floored. And she gave one of her more honest answers. She said, I don't know. I said, what, did you forget? She said, I don't know. And of course, at that point, the administrative law judge cut me off and wouldn't allow me to continue to try to find out why this woman, who is claiming that the black social worker had required these acts of fellatio from her, why she did not know whether or not he was circumcised. And that floored me. I thought at that point I had won the credibility battle. But again, my assessment of credibility was based on experiences I had, and apparently the administrative law judge had different experiences because ultimately in his decision he concluded that my client was lying and that this woman had in fact been required or had performed these 30 different sessions of fellatio upon my client, and he acknowledged that she didn't know that whether or not he was circumcised. But so that was really, I think, an indication of how my own background and skepticism based on racial understanding that sometimes white females lie about sex with black males, how that impacted on my assessment of her credibility. And you know, the final point that caused me to believe that my client may not have been lying, like I said, I don't know, all I can do is assess credibility, was that there really was no good reason for the social worker to lie about the consensual relationship. Those types of relationships do occur, and traditionally, historically, in Michigan, where they were consensual relationships, licensees did not have their licenses revoked permanently. At best, they may have been suspended, sometimes you saw reprimands because it was a consensual relationship, and the determination of the penalty had to deal with the issue of whether or not there was significant harm that was imposed upon the vulnerable client who was in treatment or therapy. On the other side of the coin, once the white ALJ issued his decision believing the white female and concluding that my client had been involved in every single act of sex that had been alleged, we need to stop and think what it might be, what could possibly have been the reasoning of the white ALJ to assess the credibility of the white female to be so much greater than the credibility of the defendant, of the respondent, of the black male. And out there in the subconscious perhaps of this white ALJ was something that somebody may have told him, or it may have been a part of his experience set, that perhaps every black man really wants to be with a white woman. And I don't think that's true, but perhaps that was a part of the reasoning of this white administrative law judge. Somebody perhaps has to protect innocent white female victims from black men who are predators. The white ALJ had for an extended period of time been a criminal prosecutor, and so maybe that experience as a criminal prosecutor caused him to believe that blacks were actually more likely to be criminals or to be involved in disreputable types of behavior. That may have been a part of his experience tool set that he used to evaluate the credibility of the black male social worker. And again, in his written decision, he indicated that even though the white female witness was confused and gave strange testimony about the alleged sexual activity, perhaps that could be explained by the fact that the sexual activity had occurred a long time ago. The white female looked very innocent while testifying, but at the same time, she had some cultural background and experiences with which the white ALJ and also the white Assistant Attorney General could identify, and these came out during examination on the record. The white female attended religious services in the same parish as the white administrative law judge, and also the white female Assistant Attorney General. So perhaps that experience on the other side of the coin caused the white administrative law judge to use his racial experience and skepticism to conclude that the black male social worker was not credible. Well, how do you see it from your vantage point? Think about it for a moment. Of course, I've described as an advocate my view of the situation, but just from what I've given you, what premises or prejudgments do you consciously or unconsciously use to decide who is lying in a she said, he said type of situation? And you will probably find that some of the premises and prejudgments that you use in a situation which is race charged probably derive from information that you gained when you were growing up relating to racial situations. Another example of how race impacts on the arbitration process when we're looking at the issue of making the profession more diverse is the fact that there are often significant efforts by parties which become obvious where they are attempting to disqualify, strike, or reject minority adjudicators, or in some situations, female adjudicators. And in fact, there is a long and documented history of parties in all different types of forums seeking to disqualify minority judges where they're deciding cases where race or discrimination is at issue. There are also numerous cases reported of parties, including state representatives or prosecutors, using peremptory challenges to strike jurors from civil or criminal cases because they were black or of the same ethnicity as the other party or the defendant. And there's a lot of case law where that particular issue about peremptory challenges based on race has been discussed all the way up to the United States Supreme Court. And those cases document the fact that this type of prejudice and activity to disqualify minority adjudicators and decision makers in litigation occurs. And in some places, and at some times, it's even been rampant. Another example of how this desire or attempt to disqualify adjudicators occurs when they are of the same background as the other party has recently come up in a case where in California, you may recall, there recently was a decision dealing with the issue of whether or not the decision by Judge Von Walker of the Ninth Circuit, which rejected the constitutionality of California Proposition 8, how that all played out. Judge Walker decided that it was inappropriate for a state referendum to take away this constitutionally protected right of gay people in California to get married, and shortly after he made that decision, he retired. Thank goodness judges can retire, I guess. It was good for me. But after he retired, it was brought up for the first time or discovered that the judge himself was gay. You can see that this is very similar to some of the considerations that we have been discussing about whether or not an adjudicator, an arbitrator who is black or minority or female can be fair in adjudicating cases where the issues are implicative or implicate topics dealing with the same demographic situation. In other words, a gay judge cannot be fair when trying to decide whether or not another gay person deserves a gay right or a civil right, however you want to look at it. And the Ninth Circuit and the Court of Appeals there has thus far rejected the arguments made by the losing parties on that Proposition 8 case that it should be remanded, dismissed, whatever, based on the fact that the judge was gay. And undoubtedly they have followed a long line of cases where the courts have recognized that there are often challenges based on the adjudicator because of the adjudicator's demographics. And that occurred here. I indicated that I dedicated this series to professors or Judges Edwards and Judge Higginbotham, and I think that both those judges have written decisions which have dealt with the decision not to recuse themselves or disqualify themselves on cases that were coming up where the issues were implicating race. And certainly those cases were fairly common during the 60s and 70s. You have to remember that during the 60s and 70s, we were seeing on the books for the first time some laws which provided civil rights and protections for minorities and other groups of people, for example, Title VII. And of course, there was a lot of litigation about what these laws meant, how they should be enforced, and so forth. And this was during the same time frame when we started to see some of the first appointments of minority and black judges and female judges to the various court panels at both the state level and the federal level. So it was pretty much inevitable that you would have judges of color and females making decisions on statutes and cases where the concerns related to race and sex. And it was no surprise that one of the attacks on those cases was to try to disqualify the minority adjudicator. And I think that history shows that almost invariably the judges who were challenged and asked to recuse themselves denied those motions because the same people who were raising those motions were essentially saying that a black judge or a black arbitrator cannot be fair in a case where one of the parties is black. Certainly that type of reasoning is very suspect because if you take the very reasoning that's offered to justify these judges recusing themselves, it would seem that the other side would be able to argue that, well, since one of the parties is white, no white judge could hear this case and be fair about it. This particular white judge would therefore need to disqualify himself. And so you would have the strange situation where essentially one group would be saying that black people, black judges, black arbitrators are less to be trusted with deciding cases impartially than white judges or white arbitrators. And I think that's very revealing, and hopefully that discussion will give you some better understanding of why I say that race does impact on decision making in the arbitration practice as well as in other types of adjudication. There are scholarly works dealing with the impact of race in legal decision making. One of the people to whom I've dedicated this presentation series, Judge Higginbotham, was a visiting lecturer, as I said, at U of M Law School when I was there back in the 70s, and he also wrote extensively on the impact of race in the courts and adjudications. He has even written some books, and I'd commend those to you if this topic is of further concern to you or interest to you. Perhaps you might want to look at his book entitled In the Matter of Color, Race in the American Legal Process, and he's also written a book and some literature that is entitled Shades of Freedom. Well, I think that is enough said to cause you to begin to understand and think about how race and gender could be issues that impact on the arbitration process, and would also hopefully give you some fodder to begin thinking about the topic of should there be diversity in the profession, because not every arbitrator sincerely believes that there should be diversity among arbitrators in the profession. And that would conclude this three-part series, which I have published and placed on the internet for your consideration. Because my involvement in this topic is one of interest which is ongoing, I would solicit and encourage and welcome any of your questions and comments. I am posting these videos on YouTube, and YouTube has a mechanism whereby if you view it, you can comment on it, and perhaps as I review any comments that might appear on YouTube, I'll get a better feel for some of the concerns, issues, other questions that need to be addressed, and I'll get a chance to enter into a dialogue with you or other people at points in the future dealing with this issue of diversity in the arbitration profession and dealing with the issue of whether or not minorities should be in this profession, and what are the issues that arise, and what are issues that are of particular interest to minorities, people of color, and female. So I appreciate your taking time to visit with me and to look at these videos. If you have not yet looked at the other two, I would invite you to do so. Take time to tweet, write me email. I am on LinkedIn, so feel free to visit on LinkedIn. Sometimes I put together polls and surveys because I am attempting to gain information about attitudes, beliefs, and experiences that relate to the profession of arbitration generally and to the more specific topic of minorities in this profession. So, if you see this presentation, leave a comment. Let me know if you can think of other issues that face minority ADRs or professionals that you believe that I should address or that I should respond to. If you have your own war stories or experiences which are personal to you that either contradict some of my premises and opinions or supplement those and support them, I'd be happy to hear about that. You can tweet about it on Twitter. I will set up a hashtag on Twitter entitled Minority Arbitrators, and hopefully people who see this series or people who stumble upon that hashtag and want to make a comment will do so. My email address is minorityadr@gmail.com. That also is the tag which you can use to find the videos when I post them on YouTube, Minority ADR. I have set up a prototype or a fledgling group on LinkedIn. I haven't had the chance yet to begin developing it, but I am attempting to get people who are interested in the topic of diversity in the profession of ADR involved, and to give them a location on a professional internet website where they can enter the group, share ideas. But again, you have to understand and realize, just like everything else on the internet, once you say it, it's probably out there. But the name of the group is Minority ADR and Justice Through Diversity. And if you're on LinkedIn or about to be on LinkedIn, stop in, ask to be admitted to the group, and share information and continue development of your own professional interest in the profession of ADR. That is the link that will get you there, or you could go just to LinkedIn and do a search for the keywords of minority, ADR, and diversity. So in summary, I hope that you've enjoyed this entire presentation. The first part dealt with specifically or generally the issues of control of the hearing process, the role of the arbitrator, and dealing with bias and conflicts of interest. The second part of this series dealt with the topic of when the arbitrator gets sued and issues related to business and operations of arbitration practices. The third segment, which you have looked at today, dealt with the topic of disclosure issues and also with the topic of race and ethnicity considerations in the arbitration process. These videos are on the internet. I've told you that they're available on YouTube, at least at this time. Feel free to enjoy, feel free to discuss, feel free to share with your colleagues and invite them to discuss and critique or supplement. I want to thank you for taking the time to sit through this series. Each of these particular presentations was well over an hour long. There were a lot of topics covered. Hopefully there was something in there of interest to you, one of the issues, some of the issues, maybe all of the issues. Again, I'm Howard T. Spence. I'm an arbitrator, an attorney, mediator, consultant, an educator and trainer. And I hope that I will get a chance to dialogue with you and get to know you professionally online at some point in the future.